Good afternoon. Welcome to the Long Live Third Parties podcast. Free Press Media Press, Inc., a third-party books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Cartwright v. Barnes, 304 F3D 1138, Court of Appeals, 11th Circuit, 2002. Friends, today we're going to deal with an argument I have not encountered yet. A new argument. A novel argument. So let us encounter it. This case involves the Libertarian Party again. We keep seeing our friends at the Libertarian Party again and again. So way to go in advancing ballot access. So what happened here? Let's read from the record. It says, quote, the appellants are the Libertarian Party of Georgia, members of the Libertarian Party who want to run for election to the United States House of Representatives in several Georgia districts, and voters from these districts who intend to vote for the Libertarian Party candidates. The appellants challenge Georgia's requirement in OCGA 21-2-17 that a candidate from a political body may appear on an election ballot if the candidate obtains signatures in a nominating petition from at least 5% of the registered voters. The main issue in this case is whether the 5% signature requirement creates a new qualification for holding federal office in violation of the qualifications clause of the United States Constitution. End quote. There you have it, friends. A new argument here. Maybe this argument has been presented in other cases. I can say I have not come across this argument. So I'd like to see our third-party friends doing what it takes to find new ways to get past these ballot access laws. So this is something we want to consider. I don't think about the qualifications clause every day. So I like the fact that they're bringing this to our attention. In this case, our friends of the Libertarian Party are arguing that this law here is putting another standard to get elected. So it's imposing something to the Constitution that shouldn't be there. It's going against the limited restrictions for running for office in the Constitution. As it says, quote, the qualifications clause provide that no person shall be a representative who shall not have attained to the age of 25 years old and been 7 years a citizen of the United States, and who shall not, when elected, be inhabitant of the state in which he shall be chosen. U.S. Constitution, Article 1 and 2, Clause 2. States may not impose additional qualifications for election to the House of Representatives beyond those contained in the qualification clauses. End quote. So yes, we want to avoid those extra clauses. How did our judges here find this argument? Did they find it persuasive? Did they like it? Unfortunately, they said this law was not actually a qualification for office, but rather a means for the state to run elections. So although it was something someone had to meet, it wasn't an actual qualification per se. Therefore, they don't believe it violates this clause. So how about you? Do you think this ballot access laws like this would violate the qualifications clause? Let me know. Let's keep rolling. Let's keep fighting the good fight of ballot access. And let's compliment the Libertarian Party for doing what they needed to do. Long live third parties. Goodbye.